Hey guys, welcome to my legal classes. This is Ganesh Pujari and today I am going to help you guys to understand one of the important and interesting aspects from the Hindu Marriage Act 1955, that is Restitution of Conjugal Rights. The term Restitution of Conjugal Rights under Hindu Marriage Act is covered under section number 9 and this is one of the important marital remedy available under this act. Now when you see the term, there is a word by restitution, there is a word says conjugal. Now you might be getting confused and you might be feeling that this might be little difficult. Don't worry, I am here to help you guys, and once you go through my presentation you will understand the concepts very clearly and you will definitely able to answer in your exams. With that, I am taking you through the next slide. The word conjugal is derived from the Latin word conjugs. The word meaning of conjugs is husband and wife. It is basically dealing with the relationship between a married couple. Now imagine a case after the marriage, wife leaves away husband without any reason to her place. Now can the husband put a case against wife for asking her to come back to his family and continue the married life? Or if there is an absence of sexual relationship between husband and wife by the negligence of one partner, can they put a case in the court? That is dealt under RCR, that is Restitution of Conjugal Rights, section number 9. Let's try and understand the legal terms when it comes to RCR in the next slide. Now let us try understand the legal language under section number 9 on Restitution of Conjugal Rights. I have made it two parts and I am reading it out and explaining it very clearly to help you guys to understand the term very clearly. Now when either the husband or the wife has without reasonable excuse withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights. Now there are too many concepts and it's very clear that the restitution of conjugal right is the right of both the parties. Husband has the right or wife has the right. When the other party leaves the conjugal life or leave the marital society without reasonable excuse, in that case the aggrieved party can put a case. Where can they put a petition? They can put it in the district court for what? For restitution of conjugal rights. Hope that's very clear. अगर husband नहीं तो wife किसी एक ने conjugal life छोड़ देते हैं तो दूसरा party can put a case in district court. That's all about the first part. The second part says, and the court, on being satisfied with the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. If the court is convinced that the petition has truth and on the basis of that there can be order to bring back the conjugal life, court can do that. That's all in section number 9. Now if we have understood that this is available for both husband and wife, when one party leaves the conjugal life, other party can put a case. The party putting case is petitioner, the other party is respondent. Now petitioner has to prove that there is absence of conjugal life, that the burden of proof on the petitioner, and court on getting convinced that there is truth available can ask for the restitution of conjugal life to the other party which has left the society. We need to remember below 3 points when it comes to restitution of conjugal rights. What are they? Number 1, one of the spouse has without reasonable excuse withdrawn from the society of the other. This should be available. What? One of the spouse without reasonable excuse, okay, withdrawn the society of the other. That should be available. Number 2, the court is satisfied with the truth of allegations made by the petitioner. The court should get satisfied with the allegations made by the petitioner. And the last one, there is no legal ground why the petition should not be allowed. The court has no reasons to decline the petition. In these 3 cases, court can give restitution of conjugal rights. Now let's look into few of the case laws in my next slide. The first case law is on Selva Madhavan versus Sulochana. What happened in this case? Selva Madhavan married Sulochana with a condition that she will leave her job after the marriage. She was doing some job. He said after the marriage she will leave the job. But she disagreed to leave the job after the marriage and they got separated due to job in 2 different locations. Now she agreed before the marriage that she will leave the job, but after the marriage she disagreed, and because of job being in two different places, they had to live separately. Now Selva put a case, and the lower appellate court held that as per the provision of Hindu Marriage Act, wife has to live with the husband. What did Selva do? Selva put a case against Sulochana, and the court, that is the appellate court, said that the wife has to come back and live with the husband. But the Madras High Court reversed the saying that Selva himself never tried to relocate. The first thing they said, Selva never tried to relocate from his job, and the second one, her job was better than Selva's job. Now with these two grounds, the Madras High Court reversed the judgment. This is Selva Madhavan versus Sulochana case. The second important case when it comes to restitution of conjugal right is Rebran versus Ashit. What happened in this case, after marriage, after some time, wife left to her mother's home and started living there. The husband was waiting for some time, and then he put a case of restitution of conjugal right. The court said, you have never tried to bring your wife back from the home, so no question arises of restitution of conjugal rights. That's happened in the Rebran versus Ashit case. The third case is Chandanaran versus Saroja Devi. What happened in this case? Chandanaran forced his wife Saroja Devi to consume alcohol and to eat non-vegetarian food, and she was not convinced with the same, so she left the husband home, and the court said she got a reasonable reason to leave the conjugal life, and the case went in favor of the respondent. Petitioner lost the case in this case. Now the fourth and the very important case when it comes to restitution of conjugal right is T. Sarita versus Venkata Subbaiah. Now who is T. Sarita? T. Sarita is one of the famous film actress of South India, and after marriage she left to Chennai, or the older Madras, and Venkata Subbaiah put a case for RCR, restitution of conjugal rights. T. Sarita said she had a film career, and if the court gives the RCR, that will curtail her fundamental rights, that is section number 14 and article 19, which is dealing with the right to equality and right to liberty. Now in this case, court held that the section 9 of Hindu Marriage Act is not valid, and they have given the judgment in favor of T. Sarita, saying that fundamental rights needs to be respected. But the very next year, in the Harvinder Kaur versus Harmendra Singh case, the court said that section 9 of Hindu Marriage Act is valid because this section is trying to bring back the relationship between husband and wife, and that should be treated in that way only. So this is all about restitution of conjugal rights. I hope I have given sufficient concept and the case laws pertaining to restitution of conjugal rights. All the very best for your exams. Thank you so much for watching me. Please subscribe, share, like and comment my videos. All the very best, and thank you again.